much for attending. We're going to cover a lot of material today. It's foreign asset protection trust, but we're going to give you a nice background. We're going to try to set you up with the idea of when we implement foreign asset protection trust as part of a general asset protection strategy. And then we're going to also do an overview of the taxation. And if you can stay awake, that's very helpful as well. We're going to turn off the video so you can see the whole slide, and we'll come back at the end in terms of putting us back on the screen. So in terms of the index, I want to see if this works. Here we go. Here's our agenda. We're going to go through basics for a few minutes. You know, you can hit the raise your hand button, and Tony will interrupt us for any questions, by the way. If you have a question, we're happy to send you a book. We love questions because it makes the presentation more interesting. But on the agenda, we'll do some basics, some background. We'll talk about how asset protection trusts work. And then we'll slide into basically the foreign trust and the keys to making them effective, along with a lot of the problems that have occurred. And then some real life examples that we found in cases. We're going to go through that. Pretty interesting what people will do, you know, in different situations. And then we'll get into the tax and how you comply on the tax side. You know, the basics of asset protection really have a lot to do with setting yourself up in a structure whereby if you were to encounter legal liabilities or litigation, you are in a situation where you don't have to worry as much about losing what you own. That's basically asset protection. It's planning. It's not finding yourself in problems and then trying to react to save what you have. That's a different issue. We actually will do an analysis for that, but that's much less effective. The idea is that long before you know of any problems, you create a structure and you kind of operate your investments and your business through the structure so that if something should come up, you're in the best possible situation. We do that through titling, exemptions, trusts, and entities. So, like for instance, with titling, Florida and most of the states on the East Coast, not so much the middle of the country and the West Coast, allow for tenancy by the entireties, which means that if you're married, you can hold assets with your spouse. If one spouse is sued, right, and not the other, or one spouse becomes subject to a judgment and not the other, those properly titled assets are not available to the creditor. So it's not a reactionary thing, but if you were to, for instance, be married by real estate or open bank accounts and you do them right by the entireties, that means you both have to satisfy the entireties, which is basically you have to buy it together and be married. And the statute allows for you to purchase something by the entireties, tenancy by the entirety. We integrate that titling a lot of times into our both entities, which is listed below, LLCs, which may be owned by trust or may be owned by husband and wife, which adds another layer of protection to the entity. The trusts are a different animal. We'll go through some of the differences between trusts and LLCs, etc. At the bottom, we see some of the similarities and distinctions. I can't tell you how many times clients and even referral sources refer to LLCs as trusts and trusts as LLCs. Totally different entity arrangement. With LLCs, the client oftentimes owns the LLC. A lot of times husband and wife, sometimes not. It's a direct ownership. With a trust, now that's assuming the trust doesn't own an LLC. So let's say in terms of owning LLCs, you own directly, and that LLC, if you're sued, is your asset. Whether someone can get to that or not is a different question. So if you own together and only one spouse is sued, you've mixed titling and the LLC. But if both spouses are sued, the LLC equity can be lien, or if it's a single member, the LLC equity can be lien and potentially, depending on the state you're dealing with, foreclosed and taken. The trust is a different animal. So we'll segue now into trusts. Trusts are basically moving assets into an arrangement whereby a trustee, usually a different person, in general it should be a different person than the grantor, basically legally owns and controls those assets. So if the grantor, the client, is sued, the grantor is not the owner of those assets anymore. It's not like an LLC. So those assets have to be somehow reached through a claim against the grantor, which is very, very difficult. So what happens with the trust is it's called divided title. The money goes into the trust arrangement. The trustee has legal title, but the trustee cannot take the assets, cannot benefit from the assets. And then there are beneficiaries who can benefit from the assets, but in a discretionary trust, the beneficiaries cannot reach the assets. The trustee has to agree to distribute those assets. And because of that split title, if a beneficiary is sued, sometimes people like to refer to that beneficiary as a trust fund baby, right? So the trust fund baby suit, the trust fund baby interest in the trust is not available to creditors of the trust fund baby. That's why for years these trust fund babies drove the banks crazy because they didn't totally understand what was going on. Well, they would sign for loans, or they have problems, or they do bad investments. Their trust fund was not available to these creditors. So that a lot of that's been corrected, but still mistakes are made with that. So unlike an LLC or another entity, the trust is really a different person than the grantor or the beneficiary. The trustee controls it for the benefit of the beneficiaries. So that's kind of the distinction between trust and for instance, an LLC. When we talk about trusts, once a month, Brian and I, at least once a month, have someone come in with a revocable trust who thinks that they're asset protected. A revocable trust, that means a trust that you could change, right? You come in, you say, I want an estate plan, or you go to your estate planner, they say, they say, you need a trust. And the client says, great, I want a trust because I think it's protected. And there's no discussion about protection. Well, a revocable trust is a trust you make for yourself or you and your spouse that you can change. If you can change it, it's not protected. So all of these revocable trusts floating around, we have people run into terrible situations where they have a creditor and they think that the assets in the revocable trust are protected. They're not. It is not a protected entity. It is a fancy will. When the grantor dies, these revocable trusts become irrevocable for a beneficiary. Then it's protected. Okay, then it's protected. But we always like to clear up that issue because it's so much confusion on this. It's because these arrangements with the revocable trust, where it's a will that's kind of a fancy will that you can change, are called trusts. In a way, they're kind of trusts for yourself, but they really should be viewed as a fancy will for protective purposes. They don't protect the asset. We have listed here on the slide special purpose trust. That's a particular, you're actually creating a land trust or a gun trust or a dog trust or whatever.
Or an educational trust for kids, or or a life insurance trust. There's different types.
That's right. And so they serve a certain purpose. Sometimes it is protective. It is a protective purpose, but typically it's not something you can generally invest through. So there's special purpose. Then you have these asset protection trusts. So from about 1500 to about 1980, that's a kind of a weird period of time. 1500 to about 1980, so you're going from the potato famine to Reagan. A lot of time you could not really create a protective trust for yourself. What that means is, if you're the grantor, you could create a trust for your child, for instance, or for really anybody else. You appoint a trustee, you put the money into trust for the child, and if the trustee's sued or the child's sued or you're sued as the grantor, the money's totally protected. But you couldn't, and even in Florida, we have it as part of our statutory scheme. You can't put money in trust for yourself and it be protected. You can put the money in trust for yourself, but if someone sues you, they can reach it. In the 80s, a few of the former British colonies said, you know what, we've got these beautiful locations and we have our we have an independent government. We'd like to get some money in. And so what they said was, what we're going to do is we're going to create law that allows a grantor to put money in trust for the grantor and maybe other people, maybe the rest of the family, and we're going to protect it. Our statute says if you use a trustee in our jurisdiction, I'm kind of paraphrasing all these different statutes. And someone sues you, the money's not available. That's an asset protection trust. Okay? And so that was so successful in the 80s that maybe 8 or 9 years later, Alaska and Delaware said, you know what, we'd like to get some money in too. And so they kind of dipped their toe into creating a statute that says, you know, we're going to do the same thing. If you take your money and you put it in trust in an Alaska, Delaware, and then you have Nevada trust, and you appoint a trustee in our state, and you follow all the rules of the statute, and someone sues you, that statute completely protects you. That money is not available. And basically, we'll work through what happened. I mean, you're still dealing with the U.S., so that's not a happy thing for a creditor in the U.S. who's used to a few hundred years of if you make your own trust, it doesn't work. So, with that being said, let's go into the details a little bit. So, a foreign asset trust is formed outside the U.S. Like I had mentioned, it may be self-settled. So, a lot of times you'll hear these words, self-settled, which means that the grantor puts the money into a trust for the grantor, right? And now, we're looking at the benefits of utilizing this structure. Do we do it offshore or do we do it onshore? Well, there's one practical issue. There's an overwhelming issue of protection, and that is offshore. Well, most of the time, we always recommend that the assets are held offshore. Okay? So if you go to court and you lose a trial, or you default on a note and it's deemed that you owe the money, which is the typical case if you default on a note. The judge now is kind of bought into the case. You have to keep in mind what goes on in the litigation. They have this long litigation. Somebody loses. The loser now owes the money, and the judge is not really excited to hear that they had a year-long litigation and a judgment, and there's nothing again. Oftentimes, if that becomes clear early in the case, it's a source of tremendous leverage. We have, we negotiate, our litigators negotiate this stuff all the time. If the person who's being sued doesn't have any money, usually shortcuts the litigation process. So, oftentimes they would actually disclose that they have a foreign trust. But what the point is that if you get to that point of a judgment, the judge has no jurisdiction over the foreign trustee or the money. The jurisdiction is over the debtor, who may be the grantor, may be a beneficiary of one of these foreign trusts, but that's kind of a steep hill to climb. We don't recommend you go into bankruptcy. Bankruptcy, there's a good chance you'll be put in jail until you disgorge what's in the trust, and you kind of are going to try to have to prove that you don't have any control over the trust. I can't get it. That's worked sometimes. It's not worked other times.
But if you have this structure, there's no reason to file for bankruptcy because you set it up.
That's right. That's right. Yeah, we just mentioned bankruptcy because we want to kind of avoid it. Like we don't want to hear about bankruptcy because the rules change and people are put in jail. We don't want to deal with that. So let's go to, I think the chart is, yeah. Let's go to some of the options on foreign trust. So the point of that was the foreign trust is much more protected. The domestic trust, we'll hit a couple cases later, is we've defended them on the defense side, but it's harder. It's harder because the assets are here, the trust is here, and we've got full faith and credit, which means if I get a judgment in Florida, I can move it to any state, and that state has to abide by that judgment. Anyway, the foreign trustees don't have to deal with any of them. We've got a couple of different jurisdictions here. We've used several of them. We've got our favorites for different reasons. A lot of that has to do with administration too. Some of the jurisdictions are much more sophisticated than others. But let's work through some of the characteristics. Foreign judgments not recognized. Obviously, that's a winner. I mean, if foreign judgments aren't recognized per se, that means in some cases you have to relitigate the claim. So did he do it? Did he not do it? I mean, everyone's going to look at each other like, are we really going to do this again? Even the collection claim. I mean, sometimes, you've got to recast that collection claim. You can't just register your judgment and collect. That's a lot of work and a lot of time, which is kind of what the driver to settlement. What does he have? Well, he has a foreign trust. Well, what do we know about foreign trust? Nothing. We've got to hire, Gary O'Brien, right?
Well, yeah, but you also have to hire local counsel in these local.
That's right, and they won't, and they're not allowed a lot of times to take it by contingency. Is that on here? I don't know if it's on there. No. So we've written into some of these laws like you can't hire local counsel who takes it on contingency, so you have to spend more money. So the more money that the creditor has to spend, obviously it's a cost benefit analysis. We've been on both sides. The less likely they're going to keep on suing, pushing, pumping with the litigation. They're going to want to settle. Some of these are pretty interesting. Settlor may retain some control. We have settlors who say, I understand the rules. The trustee has to make the distributions. A lot of that's kind of flexible, but technically the trustee has to make distributions. But I want to take a look at the assets. I want to be able to talk to the broker. I want to move real estate, etc. A lot of the jurisdictions allow for that. So you can make some investment decisions. You just have to give up the ability to get assets out of there, which is the protective issue. These next couple of columns, looks like next 3 columns, have to do with fraudulent transfer. So what happens on fraudulent transfer is if someone moves assets away from a creditor and it's proven that they did so intentionally to avoid the creditor, I'm going to give my car to my cousin. We get these people actually say, I'm going to just give my car to my cousin. There's the law in Florida, and every state has this law, and most of these jurisdictions have the law too. Interesting, a lot of the civil law jurisdictions don't have it. That's kind of outside the scope of this seminar, but they actually don't have a rule that says, like, how do I get the assets? Well, I gave it to my cousin. They don't really address it well, but the U.S. and the English-based common law jurisdictions, which allow for trust, they do have it. They do have it. You can go get the car that the debtor gave to his cousin. So can you fund a trust? So if you fund a trust and you violate the fraudulent transfer rules, well, you'll sue for fraudulent transfer in Florida, right? And we'll see a case in a minute that says, well, you probably shouldn't have assets in Florida because they can go get those assets if they were moved to avoid the creditor. But if those assets are offshore, maybe we can file a judgment, that judgment in Florida or wherever you got the judgment, offshore, where the assets are, and get the assets. A lot of times we've got to file that judgment where the trust is, and now there's a good chance that the judge is going to say, well, we're not going to follow the Florida rule on fraudulent transfer. We're going to follow, for instance, the Nevis rule. Uh-oh. The Nevis rule is not going to leave the statute open for the statute of limitations. So in Florida and almost every state, every state, actually, Nevada has a very short period, but in Florida, you've got a year after you know. So if the creditor doesn't know that there's been movement of the asset, there's always a year once they find out. They have a year. Even if this fixed statute is run, the 4-year statute, they always have a year if they didn't know. Nevis doesn't have that. So you get to Nevis and the statute's run and there's no open stay. You're out of luck. That's very common. You can see these check the box jurisdictions where you get there and it's too late. It's too late because they made the transfer while you were in litigation in the U.S. So some of this stuff is so strong it seems at times unfair. Like the next column, you've got to prove beyond a reasonable doubt that there was a fraudulent transfer, which is very hard. You get into this thing where, well, what was going on at the time? Were they doing it for estate planning? Were they doing it because they have an offshore business? Why did they do it? And you may have to prove that in a court in Cook Islands. It can be done. But you're talking about judgments that are huge, right? I mean, you're never going to see with a small judgment.
It's to put it into perspective. Most civil litigation, the standard is more likely than not. The preponderance of
you just have to prove it,
right? Yeah. I mean, more likely than not. So, but proof beyond a reasonable doubt. That's the criminal standard.
That's right. And there's no doubt, reasonable doubt that this was fraudulent. This was moved to avoid the creditor. And then you have some technical requirements where a bond is required. The creditor has to put a bond down. And it was interesting because we wrote this LLC statute in Nevis, and there's a bond requirement as well. And we looked at some of the old legislative history, and the actual Nevis people, they wanted to ensure, that bond covers fees.
Right.
So the local lawyer get the fees. Yeah. There's this presumption and the binding choice of law. What that means is you choose the law in your trust, and that the court in Nevis is going to respect that. What happens in the U.S., the big issue kind of leads us into is the courts just throw the law out. They use their own law. Here, let's see what the next slide says. This is selecting trustees and protectors. I think the next one we'll go back to with choosing the law. But the interesting part of a lot of these trusts is, people are concerned that there's a trustee offshore. How does the trustee get to my assets? Can they steal my assets, etc.? We've actually never had that happen. There are a few instances of that where they're not properly set up. But you can create a protector, so you can put your buddy on the trust, and the protector has to sign off on any distribution. It's very helpful. Some of this FATCA and this other stuff we're going to cover in the tax section. And then we had mentioned that, you can appoint an investment manager in the right jurisdiction. These are the cases. I'm going to go through them. We're going to hit them, but we're not going to spend, that we could spend 25 minutes on these cases. But I want to let Brian hit some of the compliance, also the tax and compliance. We have some CPAs on the line. We want to make sure you get everything you need. This was one of this Wells Fargo versus Barber. It's actually an LLC case, but it's very insightful. This woman, Sabrina Barber, had defaulted on a $64 million loan, and she started doing fraudulent transfers. She really had very poor guidance too. She actually had a homestead which was protected. She lost that. She started funding a Nevis LLC and certain Delaware accounts. And what happened was, actually, I thought the court could have handled it through Florida fraudulent transfer rule, because she was in Florida. So the assets were in the States. So they could have said, well, it's Florida fraudulent transfer rule. We're going to go pull those assets. We don't care where the trust or the LLC are. We're going to go get that stuff because that's a fraudulent transfer. Instead, it said, well, she's here. It's a Nevis LLC. The stuff's here. We're just going to call it a Florida LLC. I'm summarizing, but more or less that's what happened. There's a number of bankruptcy cases from mostly in the 90s that say public policy dictates that although you're using a Cook Islands LLC or a Channel Islands, English Channel Islands have trusts, we're going to call it a Connecticut trust. And Connecticut doesn't allow you to make your own trust, so it's worthless. We're going to take all the assets. So they kind of seized on this idea where they kind of said, no, you're here, the assets are here. We're just going to change the jurisdiction. Now, there's a couple of other cases that really went against that. There's a case out of Colorado, and there's a case out of I think it's a Maine and Alabama, the Arroyo case. They said that's absolutely incorrect, and I think that the Wells Fargo case is absolutely incorrect. The sad part of that case, I think they could have gotten to the assets through a legitimate means with fraudulent transfer. But the upside of that is, if the idea is to do this stuff before there's a problem. If you do it before there's a problem, very, very few cases break through these foreign trusts. The El Sala case is the opposite, where someone had they had certificated corporate stock, and they had put the certificates abroad. Clear liability. The case went on forever, actually. I don't know if it's even resolved at this point. But Sergeant sues El Sala says, nanny boo-boo, all my stuff's in the Emirates Corporation, a Dominican Republic Corporation, and the stock's offshore, you can't get it. Sergeant says, no way, you got to put this guy in jail until he gives back this money. And this court says no. It's a Florida appellate law decision, which is binding law now in Florida. So now, well, we always certificated everything, but if you have the certificates offshore, there's a good chance they're going to force you to go offshore to collect. The Rush University is a foreign trust case. It's kind of a fraudulent transfer case where this Sessions kind of moves stuff into a foreign trust to avoid having to fund a charity, Rush University. And he ended up dying, and Rush University had relied on his promise to fund construction of that hospital, and they found a way to get to the assets. So you just have to be careful.
They built a wing, right? They actually built the structure
in reliance.
Yeah.
And so it's kind of a mess. It's kind of bad acting. We don't want to do bad acting. We just want to kind of fund things in very calm seas, blue sky type thing. And basically they always work. So that's just an example of don't do the wrong thing that thinks it works. We also want to create a connection to the trust, especially if it's domestic asset protection trust, which is allowed by the 16 states, where the people, in other words, where's a trustee? Where's a protector? We want to have a trustee in the jurisdiction of the trust. Where are the assets? Did you set up your Merrill Lynch account or your Goldman account or whatever you're doing in the jurisdiction? We want to have a connection to Nevada if we use Nevada as the trust. We don't want to be able to reach assets, especially technically. The trustee and the protector, your buddy, really need to control any distributions, avoid bankruptcy because the rules change, and don't be over aggressive. We're not hiding assets. We're basically, we got to be careful. If you abuse this stuff, you will be held in contempt. They'll hold you there, especially in bankruptcy. It's hard to hold someone a long time. In bankruptcy, they held someone for 6 years. But other than bankruptcy, it's very hard to hold someone a long time because it's supposed to elicit the grantors, the debtors, action to reach assets abroad. If it doesn't, it's very hard to hold someone. It's not a criminal contempt. It's basically you violated the ruling of the court. We mentioned some cryptocurrencies and stuff. Some very interesting stuff on the high-tech side where cryptocurrencies operate, for instance, under a number, and the trustee can have half the number, the grantor can have half the number. We do very little of that work, actually, but a lot of that stuff on anonymity becomes interesting to some clients. And the professionals really should know this stuff very, very well before they endeavor. We consult with professionals. We have professionals listening now And a lot of times someone in New York City will do the estate and we'll do the offshore trust. We're happy to do that for people. I thought that was Yogi Berra, but Goldman says it's this kid, Robert Storm. I think the prediction is difficult, especially about the future. And now we're going to get into tax, and Brian is going to kick that off for you.
Now that we have a foundation of, foreign asset protection trusts and why they're used from the perspective of, if you have a client that wants to create one of these, form one of these offshore, then from the perspective of the U.S. individual, what happens tax-wise? Because as you know, the IRS, we're taxed on worldwide income. And so there are some potential pitfalls that you need to be aware of and ways that you can plan to make it as streamlined as possible. But from a basic standpoint, all U.S. persons, individuals, entities, trust, are subject to income taxation on their worldwide income. That's
what's a U.S. person?
U.S. person can be any U.S. resident, citizen, corporation, entity, business entity, trust.
Right, and we'll get into what is a resident, a U.S. resident, because it's different from the income tax resident is actually different from an estate tax resident. I know it sounds crazy, but it's absolutely true. Here it is.
That's on the income tax side, which is subtitle A, and then on the transfer tax side, which is subtitle B, the test is domicile. Mm-hmm. And so, if you're a citizen, you'll be domiciled here. But if you're a resident, you may or may not be domiciled. So you might have a green card for income taxes, but for estate and gift, you might be abroad.
You might not be a resident.
Right. So, or vice versa. So be very careful with that individually and how things are set up. And so this is just a flavor of some of the, tax implications of this type of planning. Now that you have a foundation of that, we can move on to non-U.S. And this is interesting because income tax wise, they're only taxed on their U.S. source income. So income that is made or produced here, with some exceptions, some big exceptions.
These are people that don't live here.
So for non-resident aliens or foreign entities, foreign corporations, foreign trusts, they're taxed on their U.S. source of income with these few exceptions. The major one are stock sales, which is a big truck run through the code. I mean, you can really do a lot with that. Not
oh yeah, no, we have a lot of foreign investment when people come in and buy stock. You can't do it so much with certain businesses, but people buying stock in our exchanges, all these intangible sales are exempt. They don't pay. There's no capital gains tax. It's amazing.
Then we also have to be aware of treaties, how they exist, and some of the things that they do. This is for both income and estate. Some are territorially based. So you should be careful. But again, there's some planning opportunities there. Now, if you have passive income in the United States from U.S. source income, there's a 30% withholding on that income.
On interest and that.
Right. And then for effectively connected income, basically business style income is graduated, just so you're aware of that. And so foreign trusts are unique in that they're only taxed on the real estate gains and effectively connected to income. And U.S. right, just like a foreign individual. And then U.S. beneficiaries are only taxed when they actually receive distributions from the foreign trust. The estate
we have a question.
Yes.
So we just have a quick question here. Is the U.S. Virgin Islands a jurisdiction that you also use?
We don't use the Virgin Islands that much. There's nothing wrong with the Virgin Islands, but that's a U.S. jurisdiction, which makes the transfer and collection on judgments quite easy. It's an extension of the U.S. So we don't use U.S. UVI and Puerto Rico very much. Puerto Rico is for income tax. We can move people to Puerto Rico and they don't pay any more tax. That's different. But in terms of estate planning, we don't use the U.S. holdings very much. We actually typically, if we go outside the states, we want to use a different government that's set up for foreign trusts. You agree with that?
Totally agree.
Yeah.
From the state tax side, as we discussed before, this is where a lot of individuals that are non-resident aliens can really get hit with assets in the United States. So even though intangibles can be bought and sold with no income tax during life, if you die with them and you own them individually, you have a problem, because individuals that are non-resident aliens only get a $60,000 exemption.
And there's significant planning we can do around this estate tax. But if you don't do planning, which is 90% of the people, because we know they come through our office, you run into terrible problems if someone dies. Including, we just had this thing with a husband and wife owned a mansion, wife died, and there's no transfer of the unified credit between them. Credit is very small, and there was an $800,000 tax liability just because one of the spouses had died because they acquired the property.
And through the use of a foreign entity, corporation, that could have been created.
Totally avoided.
Yeah. And then obviously the exception, the gift of intangibles, non-resident alien is able to gift U.S. intangibles, and there's no gift tax. So just something to be aware of. The same thing with treaties. Just be aware that from a jurisdiction that it has one, it might change the outcome. So what is a foreign trust? Well, for income taxes, it's pretty straightforward. A domestic trust has to meet two tests, the court test and the control test. If a trust fails both or either of these tests, it's considered a foreign trust for tax purposes as relates to the federal government. So the court test is just, does a U.S. court have the ability to bind trust operations? Where is the trust administered? If it's administered in a U.S. state or territory, it's in the U.S. That's that test. And the control test is, where's the trustee? Are they in the U.S. or not? And this can be a pitfall as well. If you have a domestic one and somebody who's the trustee dies or resigns, and then some family member overseas in the UK, in Brazil, become the trustee, you just failed one of the tests.
Now you're a foreign trust. The problem is you don't realize it for 5 years and you haven't complied, and you run into 2 years of tax litigation.
And it's important because of what happens from the income tax consequence of the creation of a foreign trust. Now, most foreign asset protection trusts that we deal with are generally U.S. residents that want to create something for asset protection reasons, not for a state or anything like that. It's just for asset protection. And so they create an offshore asset protection trust to benefit themselves and their family. That's the absolutely. And so that typically on the creation of a foreign trust, if you're a U.S. individual and you create a foreign trust and there are no U.S. beneficiaries of that trust when the creation takes place and you fund it, you actually put assets inside the trust, that's basically like an expatriation of the asset, because you have created a foreign entity and you have removed the assets offshore.
Yeah, the U.S. government does not like that.
So under Section 684, that is considered a deemed sale. So you have to account for, the fair market value of whatever it is, as if you sold it on the day you made the transfer to the foreign trust.
But typically.
But so that's the general rule. If you're a U.S. resident and you're a beneficiary of your own trust, the code says we're going to postpone that and treat it as a grantor trust as long as the U.S. grantor is alive, and there's a U.S. beneficiary.
Yeah, so when you create your own trust or you create it for your U.S. family, it's disregarded until you die, which is another problem. So it's disregarded. So all of this nonsense of if we talk to a lot of CPAs, someone comes in and starts talking to you about, I have a credit card and the credit card pulls out of my foreign trust and I don't pay any tax. It's all nonsense. You should run. The 679 came into effect years ago, and when you create a foreign trust and the grantor or another U.S. Benny is part of that trust, it's as if it doesn't exist. Until death of the grantor, then you have the deemed sale. So you have this cottage industry of, we've got all these foreign trusts, and what do? We don't want to create a deemed sale at death, so we repatriate.
And it's important to note that this discussion only relates to income taxes. It's totally unrelated to transfer taxes. So depending on if the gift has been completed or not, that's a different analysis, and it's totally different. So even if you create a foreign entity and you actually complete the gift and it goes offshore, and you use your credit amount, and so there's no estate tax or gift tax due, this deemed sale rule still applies.
So explain why that we often do not complete the gift in light of this deemed sale.
Well, from a planning perspective, the use of these, at least for us, when we recommend these to our client, this is not an estate tax saving strategy. It's for asset protection. And so we recommend that we make the gift incomplete to this foreign entity, this foreign trust offshore, with the idea that when they die, the assets will be includable in their gross estate and get, at least right now, under current law, there's a fair market value step up in basis.
Right. So the basis in the hands of the recipient rises, which eliminates, let's just say generally, eliminates that gain.
Right. There's no gain. There's still a deemed sale, but it's the fair market value,
right.
So there's no gain.
So the sequence of events has to be very carefully reviewed on the stuff. Even the repatriation of the trust, there's a lot of times no reason to repatriate if they're going to get the step up.
So just something to keep in mind. And just understand that a non-grantor foreign trust is basically treated like a non-resident alien with some unique credits and stuff, but otherwise it's offshore. As long as there's no U.S. income, there's no tax payable in the United States. But when you make a distribution of foreign income to a U.S. Benny, be careful of the accumulated income inside.
Yeah, and we'll save you the desperation.
That's a lot. Yeah, that's a lot. That'd be a lecture in and of itself. Okay, so those are the basic tax rules of having a foreign asset protection trust for a U.S. resident. Now, from the perspective of compliance. Okay, I have this. I know it's a grantor trust because the grantor is a Benny, so is his family. It's an incomplete gift, so there's nothing to file as relates to a completed gift or anything like that. And the income during the lifetime of the grantor is reported on their individual 1040. However, there are compliance requirements, informational requirements that are required to be filed each year by the U.S. grantor, who is the deemed owner of the foreign trust. They have to file a Form 3520 each year annually. So the IRS knows that the entity exists and what's going on inside of the entity. So keep that in mind, and it's due with the Form 1040. They'll also attach a foreign grantor trust owner statement, which is from another form I'll talk about next, that the foreign trustee has to file annually. So those are all filed, and the extensions are all the same as for a personal income tax return. Okay. The foreign trustee each year has to do a Form 3520A, sort of the same thing. It's sort of like the foreign account. They have to report this to the IRS. It's informational, but it's there. You need to have it, and this is due March the 15th. So a month before it would be due for an individual, and that's important because of the forms that this return, it sends out to both the U.S. owner and to any U.S. beneficiary. So not only is there an owner statement, there's also a U.S. beneficiary statement.
And how do those match up?
So the idea being is that when this is filed with the IRS, these forms go in so they know that these exist. And if the taxpayers in the U.S. don't attach them, they're not going to match them.
Yeah, sure. It's like a multi-sectional form where the trustee does the blanket.
Right. And this is required annually. So just to keep that in mind. And then for the U.S. beneficiary, their 3520, which they have to file as well, along with their U.S. beneficiary statement from the 3520A, is also required to be filed annually. And that's even if they don't receive any income, any distributions from the trust in a given year.
Just
so it's a yearly requirement every year. It's information. You have to do it. If you don't do it, you have serious penalties.
Yeah, no, and we were saying a lot of times people they slip into this idea where they were U.S. people, but when Dad died, you know, Uncle Joseph's in Holland, and now we've got, you know, foreign control. Uncle Joseph's appointed as a trustee. Uncle Joseph's in Holland. We've got a foreign trust, and there may be a little bit of assets in there. There may be a whole lot of assets in there, and no one realizes. And you slip into this compliance, and you start to accrue interest and penalties. And it's very onerous to try. There's no safe harbor. There's no way to get out of it by throwing your hands up and saying I didn't understand. It's a mess. So it's something to really keep an eye out for.
Because typically when we see this, it's been 5, 6, 10 years. So that's very, very important. Now, there are also some other forms you need to be aware of as well from a compliance statement. One is the VATCA form, the form 8938. There are some reporting thresholds. If you're unmarried or married, if you're inside the United States or not, if you're over those thresholds of assets, this informational return is also required to be filed each year with the IRS. And then lastly, if there's a foreign account, more than $10,000 in the aggregate throughout the year, you have to file an FBAR for that account. So this is some other compliance things. So if you're a deemed U.S. owner of a foreign trust,
that's it. And it has any of these accounts offshore, any asset offshore. A lot of times, what we found on the compliance with the FATCA and FBAR is that their parents moved here, and they've still got a condo or an account abroad that they've never disclosed. And there's no longer a safe harbor program. It was kind of a waste, the safe harbor program anyway. But it's kind of a difficult negotiation because it's really black letter, and it's just great to pick this stuff up.
There's no incentive for the IRS to.
That's going to close up our 50 minutes, and we're open for questions, our information. So that terminates the seminar. I think we appreciate you attending, and we'll see you next time.